So thank you, everyone, for coming. Just my preliminary note, usual PCCE rules. I wanted to mention that the keynote speech will be taped, so it will be publicly available. We'll post it on our website, but that the Q&A will be under PCCE rules, which is to say off the record. It is now my great pleasure to introduce Dean Trevor Morrison.
Thanks, Jennifer. Welcome to all of you. It's my real pleasure to introduce our keynote speaker, the Deputy Attorney General, Rod Rosenstein. Before I do, I just want to take a moment to thank Jennifer for her tireless work as the director of the PCCE. She's, for many years, been really a stalwart member of our faculty, celebrated teacher and researcher, and over the last several years, I hope you'll agree with me, has built a really special and important program based here at the law school, but of course engaging people in practice, private sector as well as government across the country. And I at least want to thank Jennifer for that, so thank you, Jennifer. We're really very grateful to have the Deputy Attorney General here with us. He is the 37th Deputy Attorney General of the United States. He's had a long and distinguished career in public service, starting at the Justice Department, I understand, in 1990, when he entered the department through the honors program. As you all know, before being nominated by the President this past January, he served as U.S. Attorney in the District of Maryland. As I say, has had a long and distinguished career in public service. We're grateful for the service he's now rendering, and really grateful that he's here with us today. So without further ado, the Deputy Attorney General.
Well, thank you very much. I'm very happy to be here. I actually spent a summer in an NYU dorm right around the corner, 110 West 3rd Street, the summer of 1987. It was my first year of law school, and I worked for Jed Rakoff. And I had the opportunity in preparing for coming here today to study up on all the criticisms Judge Rakoff has been leveling at us recently. So I was very pleased about that, and unfortunately he could not be here to ask me tough questions himself. I also had the opportunity this afternoon to visit the U.S. Attorney's Office for Eastern New York and hear about some of the great work that they're doing in the area of corporate fraud prosecutions. In fact, probably many of you have clients before the Eastern District as well as Southern. So it's been a great opportunity for me to be here, and I'm really pleased to be with so many distinguished enforcement officials and corporate practitioners and scholars from around the world. I want to thank Dean Morrison for his kind and brief introduction, which I particularly appreciate. I have one of my favorite management parables is about a child who watches her mother preparing a roast beef for dinner. And the mother cuts off the ends of the roast before she puts it in the oven. And the child asks, "Why do you do that?" And the mother says, "Well, I do it that way because my mother taught me to do it that way." So the girl goes to her grandmother and asks, "Why do you cut off the ends of the roast?" And the grandmother explains, "Well, it's because when your mother was young, we had a small oven, and I couldn't fit the whole roast in the oven. That's the reason why I cut the ends off the roast." And the moral of the story is that the solutions of the past are not always appropriate to the present. Circumstances change, and we should not blindly accept past practices. We should be conscientious about reconsidering our assumptions, but always recognize that sometimes those policies and traditions are there for a good reason. Now, my talk today will focus on the department's corporate prosecution policies, which I know is your primary area of interest. But first, I want to share some thoughts about department policies in general, given my 27 years experience now in dealing with them. I served as U.S. Attorney for 12 years, and when I wanted to find department policies about corporate investigations, drug enforcement, or most other policies, you know what I would do? I would turn on my computer and search for it on the public internet, just like you do when you're looking for department policies. In some cases, policies were modified by successive memos, so it required some historical research and reconstruction to determine exactly what it was we were supposed to do. So management by memo, that's an inefficient and often ineffective way of enforcing government policies. Our policies should be readily accessible to the people that we expect to follow them. And that's one of the administrative goals that I hope to achieve in my current job. If the department issues a specific instruction or directive and intends for it to be binding and serve as policy guidance in the future, in most cases, we should incorporate it formally into an official compilation of policies. Now, most of you are familiar with the most significant compilation of department policies, our United States Attorney's Manual. The name, you probably know, is misleading. The U.S. Attorney's Manual applies to Main Justice and all components of the Department of Justice, not just U.S. Attorney's offices. And to offer some historical context for that anomaly, our first U.S. attorneys took office in 1789, and the Department of Justice did not come into existence and open its doors for business until 1870. So the name of the manual is stuck, even though expansion of Main Justice and its many components has far exceeded the expansion of the U.S. Attorney's offices. But the upshot is that our U.S. Attorney's Manual is really effectively the Department of Justice manual and applies to all components of our department. If a policy is not in the manual, it should be in one of the internal databases to which our employees have access, much like the corporate internet portals that many of you are familiar with. I remember my days as a line prosecutor in Maryland 20 years ago. I spent many hours working on cases with the U.S. Attorney's Manual nearby, and many of you are my age or older, and you recall it was actually in a 3-ring binder in those days, not on a computer screen. And when a new policy was promulgated, it would come out on a blue sheet of paper. We would call it a blue sheet. That would be the new policy that went right into the binders. It would have been frustrating if I needed to search for policies and guidelines scattered in various places. Making policies accessible is Management 101, and one of President Trump's goals is to improve our government's efficiency in serving the American people. So if we save our attorneys and agents time searching for policies, they can spend that time fighting crime. Now, it's important to keep in mind that our internal operating policies create no private rights, despite the significant obsession that many private sector lawyers have with following our policies. They are not enforceable in court, but clear policies do promote consistency across the department's many offices and thousands of decision makers around the country. And consistency promotes fairness and enhances respect for the rule of law. Predictability and consistency also are important because they facilitate good business decisions and they promote the confidence of investors and customers. Now, the department's policies about corporate investigations are spread among various sources. We have the U.S. Attorney's Manual. We have various memoranda named for former Deputy Attorneys General, most of whom have probably spoken at this conference. We also have other memoranda, speeches, and articles restating and interpreting the policies. And every time a Department of Justice official speaks about the issue of corporate liability, as I'm doing today, it generates speculation and commentary about how the remarks affect the policies. How will it impact decisions made by our agents and prosecutors? What effect should it have on businesses and individuals who may be the subjects or targets of federal investigations? Speeches like this one, informal correspondence, FAQ documents, web pages, they all offer useful ways to explain and emphasize the department's enforcement efforts. And it's prudent to pay attention to them. But unless the remarks are incorporated in the U.S. Attorney's Manual or in some other formal department memorandum, they are not necessarily policies that govern department employees. Another challenge is that there are many outdated policy memos floating around. Their status as guiding policy is not always clear, particularly to people outside the department. And too often, department policy statements use 3 sentences to say what could be said in 1. To paraphrase an observation attributed to many a great writer, it often takes more time to write a shorter memo. A man once asked Woodrow Wilson, "How long does it take you to prepare a 10-minute speech?" And he answered, 2 weeks. So the man followed up, "Well, what about a 1-hour speech?" And Wilson replied, "That would take about 1 week." "Well," the questioner asked, "how long would it take you to prepare a 2-hour speech?" And Wilson answered, "I'm ready for that right now." Now, I should hasten to assure you that I have prepared for this. I will not detain you for 2 hours. But on the issue of memos, I regret it has become a hallmark of expertise in the white-collar arena to know the name of every former deputy attorney general who issued a memo about corporate fraud prosecutions. In my opinion, the Deputy Attorney General should not be known for writing memos. I hope you agree. Of course, the department will not stop issuing written guidance. My office is leading efforts to develop guidance about certain issues, and we support the efforts of other department components to do so. Written guidance is a critical vehicle for ensuring the department's work faithfully and consistently upholds our values and the rule of law. But we need to clearly distinguish binding policies from commentary. So my office is working on a project to collect outstanding department policy memoranda and to incorporate them, when appropriate, into the manual. Department attorneys have been identifying and collecting old memoranda and related guidance with the goal of reviewing them and making recommendations about whether to incorporate or eliminate the policies. And in the future, we should guide our employees through policies identified by section numbers in the manual or another reference source, instead of by memos named for former department officials and identified by dates. If people remember any memo that I wrote, I hope it will be a memo that calls for fewer memos and shorter memos. But when we issue new policies, they will be primarily in the form of updates to the manual, the traditional old-fashioned way. Memos generally should be brief cover memos and commentary, not freestanding policy statements. And I hope that this initiative will encourage future department leaders to issue more concise policy statements. Historical background and commentary can go in a cover memo or a press release. The substance of the policy should be in the manual, and the author should craft it to be readily understood and easily applied. Attorney General Sessions used that approach in May when he issued a new general criminal charging policy. It was crafted to fit on one page, although the letterhead caused it to carry over into page 2, but it was designed to fit on one page. And it will be incorporated into the manual, and it'll be shorter than the previous policy. So with those general thoughts, let me turn to the topic of corporate crime. The individual accountability policy issued by former Deputy Attorney General Yates is one of the policy memos under review. I don't plan to announce any new policy today, but I will discuss some concrete steps that we're taking to ensure that federal prosecutions and civil actions will effectively target corporate fraud. Of course, every time we mention that an existing policy is under review, defenders of the status quo emerge to explain that the current policy is exactly right, as if it were written on stone tablets by the hand of God. Maybe so. Or maybe every current department policy is exactly right. But in many cases, as with the roast beef story I mentioned at the beginning of my remarks, we should evaluate whether the current policy is satisfying our existing needs, whether it best accomplishes the goals that we mean for it to accomplish. I generally agree with the critique that motivated Sally Yates to issue a new policy 2 years ago. Federal prosecutors should be cautious about closing investigations in return for corporate payments without pursuing individuals who broke the law. In some cases, that practice created the appearance that we were effectively exchanging personal criminal immunity in return for corporate cash through settlement agreements in which the United States committed not to prosecute individuals. And some critics contended that our prosecutors lack the expertise, resources, or will to pursue individuals. I'm not certain that the existing memos, talking points, and FAQ documents got it exactly right. We may make some changes, but any adjustments or changes that we make will reflect several common themes. First, any changes will reflect our resolve to hold individuals accountable for corporate wrongdoing when the evidence supports it. Second, they will affirm that the government should not use criminal authority unfairly to extract civil payments. And third, any changes will make the policy more clear and more concise. And they will reflect input from stakeholders both inside and outside the Department of Justice. Corporate enforcement is an important focus of our department's criminal work, as well as our civil work. Investigations of corporate fraud and corruption are essential to promote the rule of law. And people who do business in America need to know that our laws will be enforced. All enforcement priorities of the department flow from that common commitment to the rule of law. Our duty as public servants, and particularly as members of the law enforcement community, is to uphold the Constitution and laws of the United States. The Attorney General and I emphasize that mission daily in the department's leadership offices and with agents and attorneys on the front lines. It's important to note that some corporate fraud cases also involve violent crime and other department priorities. In recent cases, corporations and financial institutions have been caught violating anti-money laundering laws, tax laws, and export control restrictions to engage in transactions with hostile foreign powers and transnational organized crime groups. In January, a large public company entered into a deferred prosecution agreement involving millions of dollars funneled to human smugglers in China. Even small companies can inflict significant damage and harm our safety and security. This summer, small businesses in Atlanta were charged with laundering $40 million on behalf of Mexican drug cartels. We also prosecute corporate fraud where the only harm is economic, because investors need to know that they can rely on corporate representations. Customers need to know that they will not be cheated. Competitors need to know that businesses that follow the rules will not be disadvantaged. Those principles are essential to the integrity of the financial markets and to American economic security. Rooting out corporate fraud levels the playing field for competitors and protects honest American workers and businesses. Law-abiding people should not have to choose between being cheated and becoming corrupt themselves. We are dedicated to protecting people who build their businesses and their bank accounts through lawful activity. The department's commitments to those values shines brightly in recent announcements of our accomplishments of our attorneys and agents. Early this week, I met with representatives of our criminal and civil fraud sections. I've also talked with other Main Justice attorneys and with assistant U.S. attorneys throughout the country and with leaders of our investigative agencies to emphasize our commitment to prosecuting corporate fraud. Many of their cases involve sophisticated fraud schemes and complex investigative techniques. Now, we aim to set the right tone about white-collar crime throughout the department. The cases can be challenging and time-consuming, and we are fostering a culture that supports and promotes the investigation and prosecution of individual perpetrators of corporate fraud. In addition to policies that encourage the investigation of individual wrongdoers, we're also taking steps to enhance our training and our culture. First, we're going to do an even better job of training our prosecutors and agents about corporate fraud, including how to build and prosecute cases against culpable individuals. We plan to schedule additional seminars at the Department of Justice's training facility to educate our attorneys and agents about corporate governance and about strategies to investigate and prosecute corporate offenses. Second, we're establishing a working group to evaluate and monitor the department's long-term effectiveness in promoting individual accountability and deterring fraud. The working group will include members of my office, the Associate Attorney General's office, the Criminal Division, the Civil Division, U.S. Attorney's offices, the FBI, and other divisions and investigative agencies critical to our efforts. It will draw on the diversity of experiences and perspectives in handling major corporate, criminal, and civil investigations. We will also review the department's practices concerning corporate monitors, the FCPA pilot program, corporate investigation training programs, and the mandate of the Financial Fraud Enforcement Task Force. Two members of our working group have accompanied me here today, Principal Associate Deputy Attorney General Robert Hur and Counsel Amelia Medina, and I invite you to share your suggestions with them, just as I encourage the department's attorneys and our law enforcement partners to communicate ideas to my staff. We're also interested in your suggestions about how to encourage better public-private cooperation in fighting crime. Cybercrime and hacking are fertile areas for cooperation. Others include financial fraud schemes, price-fixing conspiracies, and bribery. Those activities are all susceptible to detection by good corporate citizens. The department encourages employers to show leadership in picking up the phone and contacting the FBI or the local U.S. Attorney's Office to report wrongdoing. In discussing the topic of corporate misconduct, I think it's important to recognize that many American companies deserve great credit for taking the initiative to develop truly robust corporate compliance programs. The sophistication of compliance measures and tools that we see today far exceeds the processes that were in place just a decade ago. Compliance programs promote our primary goal, which is to deter wrongdoing. They also encourage prompt disclosure of wrongdoing when it comes to your attention. Sometimes the conduct disclosed to law enforcement by corporate America involves actions that took place in remote places or hidden within complex computer networks. In those situations, corporate officers often face a difficult judgment about whether to come forward and disclose the issue. They may believe that federal authorities likely will not uncover the problem. Honesty is the best policy. Albert Einstein said that whoever is careless with the truth in small matters cannot be trusted in important matters. Attorney General Robert Jackson had a slightly different version. He described reputation as the shadow cast by one's daily life. Corporations, their leaders, and certainly their lawyers develop reputations. For a corporation, the goal should be to develop a culture of integrity, a reputation for encouraging employees to do the right thing and to report suspicious conduct. That's what we seek to do at the Department of Justice. We must safeguard our institutional reputation for fairness and impartiality. That doesn't require everybody to agree all the time. It does require everybody to understand that candor and ethics matter. The Department of Justice is working to incentivize, reward, and even partner with companies that demonstrate a commitment to combating corporate fraud. That coordination may occur at the highest levels when C-suite executives and major law firms engage with the department. It may also come through the department's strong partnerships with international enforcement agencies and with federal and state regulators, some of whom are here today. It also may come from honest citizens within companies. Our department and other federal law enforcement agencies often benefit from whistleblowers. Those whistleblower programs are one reason why the department is confident about our ability to uncover and punish corporate misconduct, however well concealed. Now, in recent years, experts have debated the issue, is a company too big to jail? That question, I think, focuses on the wrong issue. We will seek appropriate corporate penalties when justified by the facts and the law. But our primary question should be, who made the decision to set the company on a course of criminal conduct? Our investigations should continue to focus on those people. We often talk about deterrence as a goal of law enforcement. What causes deterrence? Lawyers are relatively easy to deter. We are rule-bound. We're trained to follow rules. We face drastic consequences if we break them. We're deterred by the fear of scandal, let alone arrest and conviction, but not everybody is susceptible to that kind of deterrence. For 12 years, I commuted 40 miles each way from my home in Bethesda to my office in Baltimore, mostly on Interstate 95. The speed limit is 65 miles per hour. Some people take that as a suggestion. They know the enforcement strategy. And during those long drives, I sometimes thought about how well traffic laws illustrate the mission of law enforcement. Speed limit signs deter law-abiding people. If the rules are clear, most people obey out of a sense of honor and duty. But some people are not deterred by the rules. If we announce a speed limit, but we don't enforce it, the lawbreakers will always get ahead of the law-abiding people. But what if we post a speed camera? A speed camera deters many lawbreakers. They slow down as they approach the camera, and then they speed up again. It is not a complete solution, but it does illustrate deterrence. But there are some people who do not bother to slow down at all. Those people are counting on one of two things. Either they do not believe the government will enforce the penalty, or they calculate that the likely benefit to them of breaking the rule outweighs the potential penalty. And the lesson is that deterrence requires enforcement. The rules that matter most are the ones that carry expected penalties that decision makers are unwilling to pay. But focusing on deterrence requires us to think carefully about what we can achieve in our law enforcement actions. Corporate settlements do not directly deter wrongdoing by individuals. They may do it indirectly by incentivizing companies to develop and enforce corporate compliance programs. But at the level of each individual decision maker, the deterrent effect of a potential corporate penalty is muted and diffused. Before I conclude, let me take a few minutes to highlight some of the great work that our investigators and prosecutors have been doing to fight corporate crime. According to the United States Sentencing Commission, 132 organizations were convicted of federal offenses in 2016. Nearly 1/10 of those organizations employed 1,000 or more employees. Now, that statistic does not include non-prosecution and deferred prosecution agreements reached by the department, nor corporate civil settlements. More than half of the organizational prosecutions involved the separate conviction of at least one related individual. 40% of the convicted individuals were board members or owners of businesses. Others included supervisory or management level employees. Now, many of those cases did not involve well-known companies or America's wealthiest executives. Hopefully, our target corporations, our largest corporations, receive good advice about compliance and do not engage in fraud. But if they do, we'll be prepared to address it. The department will not relent in seeking to hold corporate executives accountable if they violate the law. And there have been some notable cases this year. Our U.S. Attorney's Office for the Eastern District of Michigan, along with the Environment and Natural Resources Division of Maine Justice, the Criminal Division, and other enforcement partners, secured a corporate guilty plea from an automobile manufacturer and charged several former executives with offenses related to a fraudulent scheme involving diesel cars. Our Foreign Corrupt Practices Act team obtained convictions of individuals related to bribery and money laundering offenses in 3 separate jury trials just since May. And our tax division, working with the U.S. Attorney's Office in Eastern Virginia, obtained a criminal conviction of a CEO of a healthcare technology company in a major shareholder fraud and employment tax case. Our civil fraud section has recovered tens of millions of dollars in actions in fiscal year 2017 against individual defendants under the False Claims Act, not including recoveries where corporate owners were held jointly and severally liable with the corporate entity. And by effectively combating corporate misconduct and prosecuting individuals where appropriate, we can protect Americans from fraud. We can reduce the risk of another corporate fraud episode that triggers a sell-off or a recession. We can maintain and promote confidence in the American economy. Now, that will require us to get the policies right, make the policies clear, continue training our agents and prosecutors appropriately, and provide appropriate supervisory oversight. The department's rhetoric gets a lot of attention, the policy memos and the speeches, but performance is what matters most. And we will not be satisfied until we are confident that our policies and practices fit the problems that we face today. When we're serious about wanting people to follow rules, it doesn't do any good just to post the rules. We need to make clear our intent to enforce the rules with sufficient vigor that people fear the consequences of violating them. That's the lesson I learned from speed traps on I-95, and I appreciate the opportunity to share it with you tonight. Thank you very much.